When you dial an emergency number at a moment of crisis, you expect a lifeline. The social contract feels implicit. You are in danger, you call for help, and the state sends armed professionals to protect you. Operationally and statutorily, this expectation makes sense. Legislation like the Police and Fire Reform Act categorizes police directly alongside fire and medical services as core emergency responders. For decades, the system has been built around this integrated hub. Centralized dispatchers take frantic calls and route them out, watching police to manage scenes, restore order, and coordinate with paramedics and firefighters. But there is a massive gap between operational design and legal obligation. If an ambulance ignores your call, the paramedic has failed a specific statutory duty to provide medical care. If the police fail to arrive, their legal duty to you is different and significantly weaker. By examining common law precedents, human rights doctrines, and sociological frameworks, a clear structural architecture emerges. Modern policing is engineered to enforce state order. It is not designed to serve as a guaranteed, personalized protection service. The certainty you feel when dialing 911 or 999 is based on a misunderstanding of how the legal architecture of state power actually operates. Under common law in both the US and the UK, police operate under the public duty doctrine. They owe a general duty to the public at large to enforce the law, but they do not owe a specific duty of care to protect any individual citizen from harm. The clearest articulation of this in English law is Hill v. Chief Constable of West Yorkshire. Jacqueline Hill was the final victim of the Yorkshire Ripper. Her estate sued the police, arguing that a negligently handled investigation allowed a known serial threat to remain free. The courts had to answer a specific question. Even assuming the investigation was botched, did the police legally owe a duty of care to the victim to apprehend the killer before striking again? The House of Lords explicitly refused to recognize that duty. They established that police are not legally liable in negligence for failing to apprehend a criminal who then harms a member of the public. This principle is a structural feature of common law jurisdictions. In the United States, cases like Warren v. District of Columbia and Town of Castle Rock v. Gonzales reinforce the same boundary. The Supreme Court has repeatedly ruled that neither emergency calls nor court-issued restraining orders create a constitutional or tort duty for police to protect individuals. We can map this legal architecture directly. When an emergency threat is reported and a police failure occurs, victims usually seek compensation through civil negligence. That path is entirely blocked by the public duty doctrine. Standard tort law offers no recourse. These precedents act as an impenetrable wall, rejecting individual claims of negligence. The state insulates its forces to prevent limitless liability, ensuring the institution prioritizes broad law enforcement over individual redress. While tort immunity protects the police from standard negligence claims, it is not absolute. Legal liability does exist, but it is displaced into the realm of human rights law. We see this split clearly in the Supreme Court case of Michael v. Chief Constable of South Wales Police. A victim made a desperate 999 call, reporting a credible threat to her life. The response was delayed, and she was murdered. The court dismissed the negligence claim, but they allowed a human rights claim to proceed. This alternative exists specifically under Article 2 of the European Convention on Human Rights, which governs the right to life. To succeed here, plaintiffs must meet a stringent threshold established by the European Court in Osman v. United Kingdom. The state only assumes a positive obligation to protect a citizen under specific, rigid conditions. This path represents the positive obligation established in human rights law. To trigger it, a case must satisfy 3 strict criteria simultaneously. There must be an identified individual at risk, a risk that was known to the authorities, and that risk must be categorized as both real and immediate. General risks, like a high crime rate or vague reports of danger, fail these specific tests. Most police failures remain immune from litigation because they cannot bridge the gap between general negligence and this hyper-specific legal proximity. When the police are finally held liable, the law views it as a violation of a human right by the state apparatus itself, not as a lapse by a local consumer-facing emergency service. Stepping away from case law, we have to look at the structural design driving these rulings. Why do courts consistently protect the institution of policing at the expense of the individual victim? The answer lies in classical political sociology. specifically Max Weber's definition of the modern state. Weber defined the state as the human community that successfully claims the monopoly on the legitimate use of physical force within a given territory. The police are the domestic, institutional embodiment of that monopoly. They are granted the exclusive legal authority to use coercive violence to enforce the state's legal order. Modern critical legal scholars, such as Mark Neocleus, take this further by asking exactly what kind of order the police are truly built to uphold. This visualization models the critical theory perspective. The core function of police power is securing the conditions for capital accumulation, enforcing property contracts, and pacifying social conflict that threatens the economic baseline. The safety of an individual citizen exists on this thin, dashed outer perimeter. It is a secondary, contingent function. Resources are concentrated on stabilizing the solid inner ring of the economy and the state. This is an academic observation of systemic design. Police forces do not sit in boardrooms taking direct daily orders from corporate executives. Individual officers frequently intervene to stop assaults and act heroically to save lives, but they perform those actions within an institutional framework designed to secure the broader system first. The common law immunity protecting police forces is a feature of statecraft. It ensures the state's monopoly on force and economic stability remains protected. If we return to the premise that police aren't really an emergency service, we can clearly separate the empirical facts from critical theory and identify what is strictly false. Looking at the first column of this matrix, the legal and historical reality is supported. The police act as the state's monopoly on force, and they lack a general tort duty to protect individual callers from third-party harm. In the second column, the idea that police exist primarily to protect property and corporate interests is a supported academic interpretation within critical theory, though it is not codified statutory law. The third column addresses the overstatements. Claiming the police are entirely disconnected from emergency response ignores the reality of their daily dispatch and the limited obligations they hold under human rights law. The true architecture of modern policing is complex. It is an institution tasked with upholding a specific legal and economic order. The physical protection of an individual citizen arrives as a discretionary, resource-dependent byproduct of that broader mission. The courts insulate police from individual liability because the law recognizes the institution's primary function. Their ultimate duty is to the survival and order of the state, not the guaranteed safety of the citizen.